And I'll do it again. I'm just going to tell everybody this. I do it again. And because it's so important, it goes to the whole heart of our system of justice. It's a 16.1 issue. If you have an expert doing testing, they should produce the testing.
Your Honor, just to respond to Mr. Parker, let me take the second point and I'll go to the first point. The second point is he's talking about the Capriotti case, and there was not an election made in this case that Real Water would be given the opportunity to present its insurance in front of the jury. In fact, Real Water was very careful and had objected anytime anyone had attempted to inject insurance into this case. I think Mr. Parker is confusing this case with something that happened in Judge Kishner's court. The argument about NRS 42.005 was also made in Judge Kishner's court, not in this court. It's all still fresh in everybody's mind. But again, we had argued there and we would argue here that the jury has to have some evidence to make an award of punitive damages. And NRS 42.005, subsection 4, talks about evidence of the financial condition of the defendant not being available until the commencement of the subsequent proceeding to determine the punitive damages. So in other words, the evidence that we had offered that could have been used about the financial status of Real Water during its best years could have been introduced to the jury in the punitive damages phase. And Mr. Parker actually is making an argument for us that under NRS 42.005, the evidence should have come in and did not come in. Your Honor, it gets to be kind of circular, but the issue still remains that the jury needs some evidence to hang its hat on to render a verdict. And to render a verdict of punitive damages in the amount of $200 million based on some understanding that would send a message to Dasani, or that would send a message, in this case, they argued to fire sprinkler manufacturers. That's improper, and that's not a verdict based on evidence. That's a verdict based on passion. And for those reasons, again, we think that the verdict was excessive and it should be reduced.
Lastly, I have a question for you, Mr. Odou. How do I interpret subsection 1 that Mr. Parker raised? And it says the following, quote, in addition to compensatory damages, may recover damages for the sake of example. I guess that would go to the deterrence.
That's right, the deterrence and the example. And again, you've got to have.
And by a way of punishing the defendant.
That's right. And Your Honor, as you know, as the saying goes, the punishment must fit the crime. There's got to be some evidence as to what will it take to punish a defendant. There's got to be some evidence.
You punish a defendant is in bankruptcy. That's ultimately.
And that's our point, though. There was evidence available, which was the financials that they chose not to allow the jury to know, because that could have created a punitive damages award that would have been less, and they didn't want that.
But tell me this, though, would that be truthful as far as the jury is concerned? Because if I'm giving them financials that are no longer germane and relevant because the company's in bankruptcy, how wouldn't potentially they think, well, they're an ongoing entity, they're making gross revenue of $9 million a year, and they're not actually doing that.
But that's not what the testimony was, Your Honor. And that's why we were very careful in looking for what testimony could be offered. We carefully looked through all of the depositions of all of the witnesses. And what we found was Brent Jones, who said and testified, and this would have been played for the jury, during our best years prior to COVID, we had revenue of $9 million a year. That would have been truthful. It would have been accurate. It would have been testimony as to obviously 2018, 19, arguably 20. And that could have been given to the jury. And then the jury would have some frame of reference to come up with a punitive damages number. That information was not given to the jury, it was not allowed. And so the jury had no frame of reference. It's like we talk about good faith settlements being in the ballpark. The punitive damages verdict needs to be in the ballpark, the financial ballpark of whatever the defendant is. You don't do a $200 million punitive damages award for a company that never made $200 million in its entire existence.
Anything else?
No, Your Honor. Thank you very much.
All right, this is what I'm going to do as far as all of the question is concerned. Affinity Lifestyles, DBA Real Water LLC and Real Water Inc.'s motion to alter and or amend the punitive damage verdict based upon the fact that financials, I guess that's appears to be the primary basis, were not admitted during the punitive damage phase of this case. I'm going to deny the motion for a couple of reasons. Number one, I don't think it would be appropriate to bring in their best years because we had a defunct company that was in bankruptcy. And I don't think you want to mislead the jury in that regard because that was their true financial condition at the time. Just as important too, when it comes to punitive damages, and it appears to me that Nevada law is fairly straightforward in this regard. When it talks about clear and convincing evidence and whether a defendant has been guilty of oppression, fraud, or malice, express or implied, the plaintiff, in addition to compensatory damages, may recover for the sake of an example and by way of punishing the defendant. And that appears to be, I don't know if that's peculiar to Nevada or not, but that's the thrust of the purpose of the punitive damage statute. And just as important, annihilation wasn't raised, but I don't even think it matters because the company was annihilated anyway, based upon the bankruptcy filing. And so in a traditional case where you have an ongoing company, yeah, maybe you want the financials to come in, but this company was bankrupt and they were basically done. And so the jury wouldn't be concerned about annihilation issues. And it appears to me the only thing left would be for the sake of example and by way of punishing the defendant statutorily. And so that'll be my decision. So where do we go next? And this is Hanna Instruments' motion to alter and or amend the judgment. I guess that's docket number 1291. Mr. Reynolds.
Your Honor, Mr. Gallagher will be taking this argument.
That's fine. Come on down, sir.
1291.
1291.
Hannah's motion to judgment. Are you want to do Hannah's new trial?
Yeah, I think you should do the new trials first. And whether it's
The
Hannah's,
new trial motion is 1293.
yeah.
Your Honor, would you prefer the new trial argument or
Whatever you prefer.
We'd rather have the new trial, just, it's no sense.
that's fine with us.
Whatever is best for you.
Thank you, Your Honor. Joe Reynolds, up for the record. And so this is Hanna Instruments motion for a new trial. It's difficult to start this argument after this court has already denied co-defendants a real water.
That's okay.
Motion for a
You
new
have to make
trial.
your record, sir. I get it.
But I would proffer at the outset, Your Honor, that our arguments are unique to Hanna, and our posture is unique to Hanna. This motion isn't merely a formality to check the box. Respectfully, Your Honor, under NRCP 59A, a motion for a new trial is specifically intended to give the trial court, this court, the opportunity to correct errors prior to the matters going to the Nevada Supreme Court and have months and perhaps years of briefing and review. And so this is the opportunity for the court to take action. And under the NRCP 59 standard, it says a new trial is warranted when the substantial rights of the moving party are impacted, that have prevented them from having a fair trial or where an error in law has occurred. And this is certainly the case with respect to Hanna, if there was one ever. Hanna has a constitutional right to a jury trial, and that's guaranteed in the Nevada Constitution in Article 1, Section 3, which says the right of trial by jury shall be secured to all and remain inviolate forever. Nevada Constitution, Article 6, Section 12 says the judges shall not charge juries with respect to matters of fact. In the Nevada Supreme Court in Zamora v. Price has recognized that the Nevada Constitution guarantees the right to have factual issues determined by a jury, and the right to a jury trial extends to civil proceedings. And it's against that backdrop that Hanna makes its motion and request for a new trial, as it was deprived of a fair trial in this case by the sanctions order that was issued by this court. In looking at the transcript of the proceedings in this case, there was assertions by opposing counsel that the sanction that was being proposed or instituted by this court was less severe somehow than other possible sanctions. And I certainly disagree with that. Hanna disagrees with that. And the Nevada Supreme Court disagrees with that.
But here's my question. What about the secret testing issue? And then you have the Hanna case, right? And I'm familiar with that case. It deals specifically as to whether or not an evidentiary hearing was required. Here's my point. We had, better than an evidentiary hearing, we had trial testimony in this case regarding the secret testing that was never disclosed. And so under those circumstances, I didn't need to put the witness back on the stand. He had testified to that issue. And so my point is this, and especially when it involved the secret testing, because that was a really important issue. So what do I do with that?
Well, first of all, Your Honor, respectfully, I disagree with that. And there's actually two Hanna cases. There's Hanna 1 and there's Hanna 2. And there's the proposition that when there's case terminating sanctions, and this is the rule of law, that an evidentiary hearing is mandatory. The sanctions that were imposed by this court were case terminating. This court directed the jury, and I'm reading from the special verdict form, this court has determined that Hanna is liable for plaintiff's damages. That is directed.
Now, here's my question. What purpose would an evidentiary hearing serve under the facts of this case? Because we had actual trial testimony.
And I'll jump to that, Your Honor.
Jump to that, yeah.
There were three alleged instances of testing that was referred to in this court's October 10th written order. And that was alleged to have not been disclosed by Hanna. And the first one dealt with Mr. Carl Salvaggio. This court cited one line of testimony from a cross-examination of Mr. Salvaggio in its order. And I'm reading from page 149 of the transcript. Yes, I have done testing on an MW500 probe. That is it. He doesn't say what probe, where the testing was done, when the testing was done, whether there was even any written records of that testing. And that's something that has been presumed, but the record in this case is void. The trial transcripts are void of that there's any existence of documents recording the supposed testing. That is a presumption that's not supported by the record. But what this court has overlooked in its sanction order is on page 176 of that same testimony from Mr. Salvaggio. He says, at Hanna, we hadn't at Hanna. This question pertaining to Hanna, I did not know if they did any testing. Mr. Salvaggio again states on page 177 of his testimony, no testing was done to my knowledge by Hanna. That's correct. he says and clarifies on page 190 of that testimony. And you did it on behalf of Milwaukee in referring to the testing, correct? And he says yes. So this court relied upon alleged testing by Mr. Salvaggio as a basis for sanctions against Hanna, when the record shows that his testimony was that Hanna did not do testing. Milwaukee did testing. That was omitted from this court's October 10th order. With respect to the other alleged testing regarding Mr. Brian Moore, Mr. Moore did not testify. Mr. Moore is deceased. Unfortunately, he passed away in 2018. There is no testimony in the record regarding what Mr. Moore specifically knew or not. What is in the record is statements by Mr. Salvaggio, and I'm reading from page 190. Mr. Brian Moore could have done the testing. Yeah. And then he later says, to the best of my knowledge, he did. In the end, he understood that he could have. But again, there is nothing in the record giving any context to when that alleged testing occurred, how it was done. Was it done with an NW500? What were the results? Are there any written documents regarding the testing? There is nothing in this trial record that I have seen that supports that. And with respect to the third,
But wasn't it pretty clear that they had done testing on the NW500 meter?
he says and MW500 meter. I don't know what the record doesn't show what meter, when, where. And I would also note Mr. Salvaggio.
Well, he actually says an NW500 probe.
An N500 probe, excuse me. He is not a chemist. He's not a mechanical engineer.
But I don't think he has to be. I mean, the bottom line is this, and this is what he said. Okay, let's make sure we are clear. Did you do any testing on the M as in Michael, W500 probe? Question mark. Answer, yes, I've done testing on the MW500 probe. Period, close quote. My point is this, if they did, I don't care if he had the improper foundation for even offering an opinion on the testing, and the testing was potentially inadmissible, he should have produced the testing pursuant to 16.1 at the very outset of this litigation.
And in response to that, Your Honor, I'll go back to the citations in the record that he stated that Hanna did not do the testing. So how can this court use that as a basis to sanction Hanna when he stated that it was not Hanna who did the testing? Milwaukee did the testing.
But he says, yes, I've done testing on the MW500 probe.
Yes, he does say that, but he's also clarified, Your Honor, that it was not Hanna.
Well, he tried to clarify a lot of issues during his cross-examination, is my recollection. But
and then I'll go to the third allegation about testing involving Miss Laura Brown. She did not testify. Plaintiffs opposed her testimony, so there is not a record. So going back to the court's question of there was testimony in the record supporting the sanctions order, Your Honor, respectfully, there is not. There is a vacuum in an absence of context, facts in the record regarding when this supposed testing was done, who did it, how it was done, where it was done, whether there were documents or reports that even could have been produced. None of that is in this record. And on that basis.
and whose duty and responsibility was it to produce all of that during the discovery phase of this case?
Well, I'll go back to, Your Honor, is not Hanna's duty as a corporate entity to produce documents that regarding tests that may have been done by a co-defendant or another corporate entity.
But and so do I discount this testimony when they said, yes, I have done testing on the MW 500 club? I'm not to give it, you said I.
Respectfully, Your Honor, what you were to have done is had an evidentiary hearing. And I mean that with the most respect. It will,
I understand this. I mean, I have no problems with, with you at all, Mr. Reynolds. I just want to be clear, but I mean, when I circle back to his response, yes, I have done testing on the MW 500 flow scope.
Your Honor, there should have been an evidentiary hearing where context, questions, and a thorough record was made on what that statement meant. That was not done in this case. And if we go back to the Hanna Goodyear, both of those cases, Nevada Supreme Court states that an evidentiary hearing is mandatory when there's case terminating sanctions. These sanctions.
Now, were the sanctions case terminating in this case?
Yes, they were, Your Honor.
Okay, tell me why.
Because it directed the jury that this court found that there was liability for Hanna. That's the heart of the case. And it not only did that, but it said also that there were damages. That is the heart of the case. There is no more case after that. And that was done at the top of the special verdict form. Right after the special verdict form states that Real Water admits liability, the next sentence is that the court has found Hanna liable and liable for damage.
And I don't remember with exactitude all the evidence that was submitted during the course of trial. But was there any contesting by your client of the medical causation issues in this case?
Yes, there were causation or
I'm talking about whether any arguments made by your client from a medical perspective, following the line of cases going back to Pravu versus Levine, and so on, dealing with medical causation, that the injuries sustained by the plaintiff in this case weren't caused by exposure to hydrogen at Real Water.
The arguments that I recall, Your Honor, in looking at this record, and as the court's aware, I'm appellate counsel, it was not trial counsel, is the causation arguments that were being raised by Hanna were regarding with respect to Hanna's involvement in this. That Hanna's role did not cause the injury sustained by the plaintiffs in this case. And what this court's sanction
So
was
to be clear, I guess to answer my question, you're saying, look, Judge, there was no evidence contrary to plaintiff's medical causation in this case as it pertains to the physical injuries sustained by the plaintiff. Notwithstanding, we were saying that we're not responsible in a general fashion. Is that your position?
well in both a general fashion and a more specific fashion, Your Honor, that we were not responsible, that Hanna's being even brought into this suit, it shouldn't be in this suit, let alone any link to causation by its product or its warning with respect to liability. But our argument is why a new trial is necessary is we don't know what the jury would have thought about that position. The jury was not allowed to do its job. And that's why these sanctions were the most severe that they could be.
And so how long would this evidentiary hearing have taken? We had a jury, we're in trial. How long was the trial? 6 weeks, 8 weeks? 6 weeks, right?
I don't know how long, Your Honor, the evidentiary hearing would be taken, but one should have occurred. And we'll go to, again, the Supreme Court precedent of Hanna versus Goodyear. Case terminating sanctions require an evidentiary hearing. And I would alternatively note, even if this court disagrees that the sanctions are not case terminating, There was two Bahena opinions. The first one by the court, and then a subsequent opinion on rehearing. And on rehearing, the Nevada Supreme Court, and I'm reading for Bahena 2. District courts should be encouraged to exercise their discretion to hold an evidentiary hearing regarding non-case concluding sanctions when requested. And I'd note, Your Honor, such a hearing was requested both by Milwaukee's counsel and agreed to by Hanna's trial counsel. And when there are disputed issues of material fact regarding the discovery dispute identified by the parties. There are absolutely disputed issues of fact regarding this dispute. Hanna's trial counsel, Mr. Rasmussen, disputed those contentions. And again, the record is void of context and a basis for even this court deciding whether the nature, the scope of the testing was prejudicial or not, and whether it even existed, who did it, and where it was done. That is not in this trial record.
But we know, I mean, according to the testimony, Mr. Savaggio, did he say, yes, I've done testing on the MW 500 probe? Pretty close quote.
Yes, he did. I see it that he did. He said "an probe," and he gives zero more context. And Your Honor, that is one statement out of an entire context of testimony. And I again draw the court's attention back to the statements that he stated that Hanna didn't do the testing. Reading both of those.
Well, the only reason I bring that up, I mean, I thought, and this is, I think the record shows this, Mr. Savaggio was all over the place as far as his testimony is concerned.
And Your Honor, all the more reason to have an evidentiary hearing. Have an evidentiary hearing to allow.
You're saying I should not take him at his word. That he says, yes, I've done testing on an NW 500 probe. Close quote.
What I'm saying, Your Honor, is he also stated that that was not Hanna testing, that Hanna didn't test. And as I'll read again.
Because this is my recollection, there was some drilling down, and ultimately he admitted that they had done testing, right? And so I don't mind saying this when there's and for me, it's a huge red flag. If issues come up regarding testing and someone admits that they had done testing and the testing wasn't produced, that's a huge red flag.
Well, Your Honor, in this goes partly then to the Young factors and how this court, is to analyze potential prejudice. Even as assuming there was conduct that was sanctionable, and I'm looking at this court order, and the court order and going through some of the Young factors. Talks about the degree of willfulness of an offending party and asserts that there was concealment. There's no evidence in the record of concealment. Concealment implies intent, implies willfulness. There's no showing in the record of intent or willfulness to conceal.
Well, can I presume that if it wasn't disclosed pursuant to 16.1, because you're not taking a position that, assuming I take Mr. Savaggio's testimony at face value, where he says, yes, I've done testing on a MW 500 probe, that I shouldn't accept that and then make a determination as to what the potential violation would be. And here's my point. And if we can go through the entire analysis and looking at it, at this point, we were probably 4 weeks into trial when this happened, right? And this is something that if there was testing, he should have produced the testing probably at the point of the 16.1 early case conference disclosure. And just as important too, if it was done subsequent to that date, then there should have been a production as soon as that testing was accomplished, right?
To that point, Your Honor, I'll jump to, NRCP 37. subsection C, which says if a
Substantial justification and or harmless. I don't see any substantial justification, and potentially I can see where it can be really harmful.
well, Your Honor, again, there's not an evidentiary hearing for this respectfully to be able to accurately make that determination about the nature of its harmlessness. If the court doesn't know when the testing occurred, what the testing results were, whether it would even be admissible evidence, how can there be a harmlessness determination one way or the other?
Well, I can make that because if the testing occurred and it wasn't produced, I think there can be potential inferences as a result of that too. I mean, why wasn't it produced? And I mean, I think that's really an important issue. And maybe it's more important to me as a trial judge than others. But if there's any testing done and it wasn't disclosed, that's a problem. And it just is.
Your Honor, those are questions that should have been asked in an evidentiary hearing. And that's why our argument that a new trial is warranted because there wasn't an evidentiary hearing to answer those questions. Going back to the Young factors, there was whether the evidence was lost or irreparably lost. Here, there's no showing that any evidence was lost or destroyed.
Well, I think it's lost procedurally because it was never produced during 16.1, right? Because you can't just produce testing at the time of a hearing. I mean, especially when it comes to testing on a product. And here's my point. Number one, whatever testing that was performed should have been produced timely. Secondly, just as important too, the adverse party has a right to have their expert review it, right? And make a determination as to whether or not they have some sort of rebuttal response and those types of things. And we all know that, you know, and but the other side was, number one, it wasn't produced, whatever it might have been. And it could have been harmless or it could have been significantly prejudicial. We'll never understand, or we'll never know that answer unless there's a new trial. But my point is this, it should have been produced.
In respectfully, Your Honor, produced by who? Because
by Mr. Savaggio and his principal.
And then when he testified, which he did, that Hanna didn't do the testing, why is Hanna sanctioned on that basis?
Well, he testified that I did testing. I'm
Yes,
taking his word at first face value.
In Your Honor, and Hanna's position as a corporate entity is that this court is holding and sanctioned Hanna for that. And when he stated,
who was Mr. Savaggio vis-a-vis Hanna? What was his?
He's a vice president at Hanna. He's a president at Milwaukee,
right.
Or at least was at the time of the trial. But he clearly stated on the record.
Could he bind Hanna in Milwaukee based upon his testimony?
I don't know the answer to that, Your Honor. But I would say that that question, overlooks that he testified that it was Hanna's. Hanna didn't do the testing, and so how can this court hold Hanna liable for sanctions under Mr. Savaggio when he testified that Hanna didn't do the testing? And our argument is that there's an abuse of discretion in that is error, and going and gather Young factors, and again without the prejudice, without an evidentiary hearing, this court doesn't know prejudice, the extent of prejudice, and whether there is any at all. And the other Young factor, whether there is unfairness or unreasonableness of the sanction to the other party. Again, without an evidentiary hearing, this court is not adequately able to make that assessment. And then with respect to the Young factor of policy favoring the adjudication on the merits, in this court's written order, it states this matter will still be determined on the merits. Respectfully, Your Honor, that's incorrect. The matter wasn't determined on the merits. with respect to Hanna because the special verdict form instructed the jury that Hanna was liable. There was not a merits determination.
What about, counsel's, argument regarding Laura Brown doing testing?
Your Honor, our position is Laura Brown, should have at a minimum be permitted to testify as a witness at an evidentiary hearing to find out exactly what was going on there, the nature, the scope of that. Without an evidentiary hearing, the record is void of that. And without knowing that information, how can a determination be made as to whether it was prejudicial or not, and as to whether under NRCP 37 it was harmless or not? The consequences of the inferences, Your Honor, is a $38 million sanction, which Hanna is joint and severally liable for. A $38 million sanction. Under the Supreme Court's case in Emerson, sanctions must be reasonable and proportional. $38 million, even if the conduct alleged was true, is grossly disproportionate. And in fact, a $38 million sanction for this is respectfully unprecedented. That's all the more true in light of the special verdict form, Your Honor, that we had briefly just touched upon. Again, the special verdict form directed the jury that Hanna was liable. And I read, this court has determined that Hanna is liable for plaintiff's damages. Throughout the rest of the special verdict form, there is no mention of Hanna on questions 2, 3, 4, 5, 6, 7, 8. 9, 10, 11, 12, 13, 14, 15, and all the way then till the end. The last one is Hanna liable for punitive damages, which the jury said no. The way that special verdict form is drafted in context of the larger sanctions issue is an alternative basis, and another basis is why a new trial is warranted in this case for Hanna. That verdict form is extraordinarily prejudicial in the way it's drafted and in the way it's laid out. And it's thoroughly ambiguous regarding its meaning in what the jury intended in this. The other arguments we respectfully as to why a new trial is warranted is also this court's exclusion of Dr. Babcock's testimony. He was a witness, an expert witness that was proffered by Hanna, that Hanna wanted to introduce. He had a PhD from the University of Chicago, and he did conduct testing and would have testified about the results of that testing. This court denied his ability to testify. And so on one hand, we have an expert witness who has training and expertise in testing that this court prevented from coming on the stand and testifying. And then on the other, there is Mr. Salagio, who has no expert training in testing regarding chemistry and mechanical engineering, that this court is sanctioning Hanna for not allegedly disclosing test results. We believe that this is another basis as to why Hanna was deprived of a fair trial in this case.
I mean, for the record, I didn't exclude Mr. Savaggio because he didn't meet the qualifications requirement under Williams. That wasn't the thrust at all. The thrust was he failed to disclose testing that had been conducted. And whether, say hypothetically, if he had disclosed the testing during discovery, then if he was challenged based upon qualifications, then I would have made a decision based upon potentially what the issue was. But just as important, he could have had Ms. Brown or someone else do the test. That, you know, and that's kind of my point. The bottom line is the testing should have been produced. But go ahead, sir.
Thank you, Your Honor. Respect to Hanna's renewed motion for a judgment as a matter of law. Those dovetail into certainly its motion and arguments for a motion for a new trial. And specifically, Hanna's expert, Dr. Fortenbaugh, testified that the MW 500 instructions were adequate, gave proper notice that the electrode needed to be conditioned in the length of time of conditioning. That was expert testimony. That was in the record. Compared against plaintiff's witness, Dr. Motley, who similarly testified that the instructions on the tip card should have been included in the instruction manual. Moreover, Hanna renews its motion for a judgment of a matter of law on the assertion that there was an inherently dangerous product. Dr. Motley testified that the MW 500 was not an inherently dangerous product. The difficulty in the renewed motions for judgment of a matter of law, though, is that they're partly or all the way negated by this court's sanctions order. And it goes back to, Your Honor, that we were denied our day in court. We were denied our fair trial. We request that this court grant Hanna's motion for a new trial. The remaining arguments we submit on our motions.
Thank you, sir. Who's handling the next? Who's handling the opposition?
Your Honor, and I was going to ask you want to break for lunch?
Yeah, I think so. We want to break down. Yes, yes, sir.
Affinity had joined just the motion for new trial in reference to the Batson challenge. Okay. That is our document 1303. I just wanted to note that for the record. I don't have anything to add.
I understand. And what time is it?
Your Honor.
Yes, Mr. Park.
I have the reason why I'm in South Carolina is because of a meeting I have that starts at 5:30 Eastern Standard Time. The associate who would normally handle it, he's unfortunately unable to do so, and that's why I'm here, which is roughly 2 o'clock our time. Giving me 30 minutes to get from my office to the meeting I have to go to. There's a part of this motion I wanted to argue as well, and then the other motion I wanted to argue in particular. I don't know if we'll get to it today, but is there any way we can put that one off till Wednesday? Unless Mr. Kemp wants to, I'll defer to his wisdom on whether or not he wants to take it today if we have time. I don't think we're going to have time for it, but it would be the last motion, the motion for fees, costs, and interest. I think that would be the last motion you'd handle.
Your Honor, I'm happy to work around Teddy's schedule for.
We're going to work around everybody's schedule.
Yeah.
I mean, I'd have sent you to lunch if you would have wanted to go, Mr.
You did, Your Honor. You're the best.
Yeah, but
why don't we move the fees to Wednesday?
They're telling me now. I mean, I don't mind telling you this. I just looked at my calendar the day coming up, right? And so my staff was kind of in charge of my calendar because I mean, there was a time I'd look you know, when I was still had lawyer in me, you always look next week, the week after, and so on and so on. I'm at the point now where I go almost day to day, you know, and so and they're telling me we have problems.
Yeah, Wednesday is already a full day for us. So.
I can do Thursday.
No, the soonest we have is March 8th.
Is that because of trial?
We just have all the sessions, motions and
Yeah.
special
Why don't
settings.
we finish this
There's
one
enough.
and move everything to March 8th?
March 8th, we have a Ninth Circuit argument.
It was weak.
Abe and I.
I'm just kidding.
In your honor, I'm out of state on March 8th.
Okay, well, we're not, if you're out of state and you have a Ninth Circuit argument, that's a problem.
I'm more than happy to, if the court is inclined, Your Honor, I'm more than happy to finish this one and you finish whatever and then
But
take
you,
the
but you
line.
can't, but my point is this though, Mr. Park, I don't think you can finish it in like 3 minutes.
No,
No, you're right,
we
Your
come
Honor.
back at 1:30, we can finish it in half
Oh,
an
that's
hour.
problematic too.
Well, we can let Ted.
We can do
a
March,
shorter
how's
lunch.
March 4th?
I just told somebody else it was good.
Yeah, I mean, if we came back like Mr. Kemp is saying at 1:30, then we could at least finish this one and maybe one more.
I think it'll be a little bit later than, I'm thinking 1:45, right?
Okay, then maybe we can finish this one and then everyone can check their calendars over the lunch break.
Makes sense to me.
Is it? What do we want to do? You
Finish this up at 1:45.
want to try to do that?
Go through to 1:45.
No. Come back at 1:45 and then we'll finish up this motion, maybe break for the day. Assuming that will accommodate Mr. Parker. If that doesn't accommodate Mr. Parker, we're done for today.
No, I don't think it would accommodate him.
That wouldn't accommodate.
No, I'm fine. Listen, if I think we should be able to get done between myself and Mr. Kemp arguing the opposition, I think we should be able to get done, by, I would think in the next 15, 20 minutes after we return. So we return at 1:45. Hopefully we'll be done by
I think
2:10. Maybe I'm being a little optimistic.
I don't think your co-counsel agrees with you on
no. What date you got there?
that. No.
Abe's reluctant to say yes to the 4th because it's 4 days before a Ninth Circuit argument, but
March 4th?
I can do that.
I can do it if the judge, if you're available, March 4th, Judge.
I'm here. What did Judge Guy say?
March
We're
4th.
paid by the year.
We get paid by the
I
year.
steal that line.
I'm gonna, maybe I'll start using that. It's like March 4th at what time?
Week after that's really good.
How's March 4th at 10:00 a.m.?
That's fine, Your Honor.
Sure.
Yes. My guess it's not that. It seems like March 4th is way down the road, but it really isn't.
It isn't.
Like next month, Judge.
I know, and today's the 26th, right? That's actually what, 1 week and 1 day? Yes.
That's it, Your Honor.
Just to clarify, we're gonna,
1:45.
and we.
No,
there are
we're done. We're
motions-
done for,
There are all
we're done.
motions that he doesn't need to be part of.
Right. We're done for today. We'll be back at 1:45 to continue. I'm sorry, we'll be back on March
4th at 10 a.m. And
Okay. Okay.
our JEA would like to move the motion for the 28th
The
to
10.
that same day, March 4th.
It's 12:22.
This is what we're gonna do. We're gonna come back at March 4th at what time?
10 a.m.
And we're just gonna continue our journey.
Okay.
And matters that are currently set for the 28th might get heard that day too.
Judge, not everybody on my side can make that.
I'm sorry, I think Mr. Parker is specifically discussing this motion.
Right.
Are there other motions that we can argue today
Or this
that
afternoon, you
do
mean?
not involve Mr.
Comfortable break. I can.
Yeah, I'm fine.
Okay. Be right back.
What time?
Judge, may I suggest we come back early from lunch, finish up this one, and do a bunch that Teddy's not involved in?
I'm fine with that. I'm fine with that.
Yeah, get as much done today as we can, because I've had this booked for blocked off
I
for a
understand.
long time.
So Your Honor, if we get back, like you were saying, at 1:45, I can argue my argument will be very short on this one.
Actually, it's taking, the more we talk now, it's gonna be 2
Yeah,
o'clock.
so why don't we
It's
leave
gonna be 2
now?
o'clock
Let's
now.
just come back at 1:45. Teddy can argue.
Well,
Yeah,
actually,
that sounds
what time
great.
is it now? Yeah, it's gonna be 2 o'clock. 2 o'clock. But that's-
Okay, that's fine. We'll come back at 2 o'clock. I'll be finished with my argument in less than 10 minutes. And then Will can do his argument, which will be longer.
Okay, we'll do that. 2 o'clock.
Well
Sounds
done.
great.
I can say that Teddy's arguments are always better.
2 o'clock.
Thank you, Your Honor.
That's Dan really complimenting himself since he mentored me for so long.
There you go. Judge is gone, Teddy.
All right.
Okay. I guess, Mr. Parker, you're next up, right?
I believe so, Your Honor. Good afternoon. Can you hear me okay, Your Honor?
Oh, we have a very clear connection, Mr. Parker. We can hear you and see you.
Perfect. So, Your Honor, I wanted to start off with, first I will say that the opposition filed by Mr. Kemp's office on behalf of the plaintiffs, I think is very thorough. And I don't know if the court has any questions simply based upon the briefing or something raised earlier by Hanna's counsel. If the court does not, then I'll generally provide my thoughts on the matter.
None at this time, and I'll say this for the record, Mr. Parker, I do remember the trial very well.
Thank you, Your Honor. And certainly, Your Honor recalls that Mr. Salvaggio was the vice president of Hanna and the president of Milwaukee. And one thing that I thought that Hanna's counsel did not bring up earlier today is the fact that that Hanna's counsel brought Mr. Salvaggio to the stand. He was not brought to the stand on behalf of Milwaukee, but he was brought onto the stand on behalf of Hanna. And he chose to give what I would consider extensive direct testimony regarding his knowledge of testing. And when it became clear to us that there was testing that was not produced in accordance with 16.1 or identified in response to request for production or identified in terms of witnesses, Ms. Brown, in answers to interrogatories, we brought that matter to the attention of the court. And then Mr. Rasmussen, who brought Mr. Salvaggio to the stand, admitted, which is in the record and certainly presented in our opposition papers, that testing had been done by Hanna because Mr. Rasmussen represented Hanna and made those comments in the record. And at that point, the court ultimately issued the sanctions that were, again, less than what the plaintiffs wanted, but certainly less than a striking of its answer. Your Honor, if you recall, prior to trial, we brought a motion for sanctions because of what we believe to be inappropriate discovery actions on the part of Hanna. The court did not grant those. And then during trial, when this happened, we were weeks into trial at this point, we find out, not in our case in chief, but in Hanna's case in chief, that they held these documents back. And so, Your Honor, or the testing, I should say, back. Ultimately, we found out over a month after trial that testing had been performed by Hanna and Laura Brown was involved in that testing. So, Your Honor, first looking at this case through a Behena lens, this was not case terminating sanctions that were imposed. Again, it was less than what we asked for, but certainly it was not case terminating sanctions. Hanna's counsel called it went to the heart of the case, but there's no condition or caveat or instruction from the Supreme Court saying that if the issue goes to the heart of the case, you have to have an evidentiary hearing as you would in terminating sanctions. And nor did Hanna's counsel request an evidentiary hearing. Fortunate for us, the testimony of Mr. Salvaggio happened in front of the court. The statements made by Mr. Rasmussen happened in front of the court. So the court didn't have to take that from plaintiffs' position. It didn't come from a deposition taken outside of court. All of these things happened before the court, during trial. And so the court had the pleasure of experiencing the revelations before it. And so, Your Honor, I want to make sure that Hanna's counsel, and again, Hanna's counsel currently, who brought this motion today, was not trial counsel. So I understand if he was not aware of all of these particularities, but certainly that's how it played out during Mr. Savaggio's cross-examination, which I had the pleasure of doing. And then Mr. Rasmussen's comments coming roughly during the same time.
And when you
Your
talk about Mr. Rasmussen's comments, are those the specific comments that would be set forth, I think, on page 7 of the opposition?
That is correct, Your Honor, where he actually identifies Ms. Laura Brown, who was not previously identified in answers to interrogatories. And he said that Laura Brown, who's apparently an employee of Hanna, performed testing. And one of the things that you pointed out, Your Honor, when discussing this motion with Hanna's counsel earlier, was that the plaintiffs, based upon written discovery, would have been entitled to the testing results. The testing protocol, all of those things should have been disclosed pursuant to 16.1 and specifically in response to written discovery propounded by plaintiffs. You also pointed out, and I don't believe Hanna's counsel addressed it, but even if it was not produced initially, there's a requirement to seasonably supplement your written discovery. And so they knew that this testing was done and failed to produce even information that the testing had taken place, even if the results had not been received yet. And we weren't informed of any of it, Your Honor, much less the witness who was involved. And so Your Honor did less than what we requested. Certainly, we believe that this should have gone straight to punitives as well, but the court was very judicious and tempered its decision by giving less or issuing less than case terminating sanctions. And Hanna had the ability, because we had already put on our entire case in chief, to cross-examine all of our witnesses. Additionally, you gave Hanna the ability to provide testimony, which was successful for them because they were not found to be responsible for punitive damages. They also contested the value of the plaintiff's claims. So much less than terminating sanctions were imposed, Your Honor, and so the Bahina case does not support their position. In fact, I believe the Bahina case supports our position because it wasn't terminating sanctions. Unlike I believe Mr. Polsenberg and Bahina suggested and argued that terminating sanctions necessitated a evidentiary hearing, and he requested it on behalf of the defendants in that case. That didn't happen in this case. In this case, Mr. Rasmussen did not ask for an evidentiary hearing after the revelation before the court and to the plaintiff's attorneys that testing had been done and that Ms. Laura Brown on behalf of Hanna was involved and that Mr. Savaggio was aware of it. And so I don't believe the Bahina case helps the Hanna's position, Your Honor. I also believe that under Rule 37, the court was correct in not allowing Ms. Laura Brown to testify. I think under Rule 16.1, under Rule 34 and 33, the court, given the testimony, was, I think, properly decided that liability should be decided against Hanna, given its misconduct, Your Honor. So in terms of that, I don't see where Hanna has a persuasive argument on a new trial. The other thing I wanted to point out, Your Honor, in terms of liability, and this is why I don't believe it was that the court went as far as we wanted, certainly is not as far as I wanted the court to go. You heard testimony during trial from Mr. Brown and Mr. Savaggio that there were 6 different recommendations given at different times on how to condition the probe. One instruction was roughly 5 minutes. Another one was 24 hours, 2 days, 3 days, 4 days, and ultimately 5 days of conditioning with a certain type of vinegar prior, if you recall, they originally had a solution that the European market determined was toxic and would not allow them to use it any longer. And so it was admitted, Your Honor, virtually, that they gave improper instructions on conditioning. They never actually clarified it through their tip card. And you remember us putting the tip card in front of the jury. And there were no other instructions on the box that gave the purchaser any clear direction on conditioning of those probes. Your Honor, there's no way that Hanna can support that this court went too far in its assessment of or imposition, I should say, of the sanction of simply finding liability against them and allowing them to argue damages and to allowing them to put on the remainder of their case in chief in terms of punitive damages, Your Honor. The other portions of the brief, and I don't know if the court would like me to go into this, but one thing I wanted to hit, in addition to what I suspect Mr. Kemp will talk about, is the Batson challenge. And if you recall, Your Honor, during the Batson challenge, this was a black male that was sought to be removed by Hanna. And we asked for, pursuant to the Edmonds case, we asked for the race-neutral reason behind the challenge. And Hanna's counsel had no response. The knee-jerk response ultimately was, well, Mr. Parker, you struck the Native American person. And first thing is, no one knew that she was Native American. We informed them, although they waived the right to even challenge the cause challenge for that potential juror, we still informed them why. And Mr. Rasmussen, when asked more than once what the race-neutral reason was, he simply had no response. And so for Hanna to try to use it now, I think it's inappropriate and certainly is unsupported by the transcript in this case, Your Honor. The other arguments in terms of Dr. Babcock, Your Honor, Dr. Babcock was properly excluded because he didn't use the right meters. I mean, it was just that easy. And as a result, his test was not analogous to the testing using the correct meters. And the court made it clear, and we had extensive briefing and protracted arguments. And in fact, if the court remembers, we started the pretrial motions, the motions in limine, in July and didn't finish until the day before trial started, all the way to September 5th. And the court took under advisement certain of those decisions and then came back within that time period, over a month worth of time devoted to pretrial motions, going over why Babcock would not be allowed to testify on inappropriate testing. So, Your Honor, I don't fault appellate counsel for not knowing these things, because it would take a long time to read through all of the transcripts and all the motion practice that went before trial. But certainly the court has a very good recollection of those events and how much time and effort was devoted to going through each one of those motions, including the motions in limine related to Mr. Babcock, Your Honor. I believe that addresses the points I would like to address, Your Honor. If the court has any questions, I'd be more than happy to address them.
Thank you, sir. None at this time.
Thank you, Your Honor.
Okay. Mr. Kemp, anything you want to ask?
I don't have anything more.
Okay. We'll hear from the reply.
Thank you, Your Honor. Joe Reynolds for the record. With respect to the assertion that an evidentiary hearing wasn't requested, I draw the court's attention to pages 61 and 62 of the trial transcript on October the 2nd, where Milwaukee's trial counsel, Mr. Robbins, said, "I'm requesting that we have an evidentiary hearing on that issue because I do not think the record is clear." And his trial counsel, Mr. Rasmussen, replied, "I agree. There has been no record on this."
Here's the thing now, record on what? There was testing done and it was never produced, right? So what do I need to have evidence for? There was testing done. Secondly, and I don't mind telling you this is what I really found troubling at the end of the day, because I remember this like it was yesterday, and this is when counsel made this statement straight out of the record, and this is on page 7. Says, okay, real simple. Laura Brown has done testing. That doesn't mean I was going to put her on the stand to do that. I believe Mr. Parker is making an assumption as to whether or not she would be able to talk about the testing she's done because I haven't provided that. I can't do that, but her test. And then he goes further. She did testing back in March, but her conclusions hadn't been done. That's a problem. I don't mind saying it. That's a problem. But continue on, sir.
Thank you, Your Honor. Our argument is that there should have been an evidentiary hearing. And again, I draw this court's attention to Bahena 2, where the Supreme Court.
We had evidence, right?
Your
We
Honor,
had direct testimony and argument of counsel. It had not been produced. So I don't need to perform a full-blown evidentiary hearing vis-a-vis the admissibility of the testing. Bottom line, it wasn't produced, right? And we know Laura Brown, I mean, unless, and I think counsel's being correct in what they said here. She did testing back in March, but her conclusions had not been done, right? Should have been produced. And you know what? There's no substantial justification for it. And we don't know if it was harmless or not. I feel very strong. If I have someone admits in open court, we did testing. Am I required to conduct a hallmark analysis on the testing before I make a determination as to whether or not there should be sanctions for that? I don't think so. But go ahead.
Your Honor,
And the only reason I'm saying I want the Supreme Court to think about that.
Your Honor, I respectfully disagree. And I'm quoting the
That's
Nevada.
okay. You got an appeal. I'm just telling you, if testing is done and it's not produced, that's a problem.
Your Honor, in our argument is not that whether testing should be produced or not. Our argument is that the sanction that was imposed by this court and
I'll do it again. I'm just going to tell everybody this. I do it again. And because it's so important, it goes to the whole heart of our system of justice. It's a 16.1 issue. If you have an expert doing testing, they should produce the testing, right? And because I've actually found this a little troubling. And here's the excuse. Well, she did it, the testing back in March, but her conclusions hadn't been done.
Your Honor, again, I'm quoting Supreme Court in Bahena 2. District Court.
I had an evidentiary hearing, this trial. That's my position. I don't take positions. I had an evidentiary hearing. It was this trial, right? And I had trial testimony. What else did I need to know? Are you because what you're asking me to do? Look, Judge, go ahead. You had to do a hallmark analysis and make a determination as to whether that testing would be admissible or not, right? Because we know they did testing. Should have been produced.
Your Honor, the Supreme Court, again, has.
I had an evidentiary hearing the trial. That's what that, and let the Supreme Court grapple with that. And I can't think of a better evidentiary hearing than a trial. And it was admitted that there was testing during the trial. I don't think I have to hold a hallmark hearing to make a determination as to what the appropriate sanction should be. I don't think so.
And I respectfully disagree, Your Honor.
That's okay. We'll let the Supreme Court deal with that. Because if a trial is not an evidentiary hearing, I don't know what is. It's the evidentiary hearing in the purest form, right? Trial testimony on the stand in front of me, an argument by counsel. If I can't rely upon that, let the Supreme Court tell me specifically what I should do from a hearing perspective. Because I had actual trial testimony. The testing was done, wasn't produced, and then we had an excuse. And I'll leave it at that.
Your Honor, in to conclude, and I've heard what the court has to say, and we submit that an actual evidentiary hearing was required. It was abuse of discretion to not have an evidentiary
That's
hearing.
okay. That's okay. But the Supreme Court's going to want to know why I did what I did, right? And I'm telling them I did it because I had trial testimony. I had an admission as there was testing. I don't think I have to perform a hallmark type of analysis to determine what the potential harm might be. The testing should be produced, right? Because hypothetically, the testing that, oh, we haven't done the conclusions yet, could have benefited plaintiff. And we'll never know that because they should have produced it. Because you can make all sorts of arguments about that. But they didn't produce it.
And again, Your Honor, our argument isn't a production argument. There are questions that are outstanding about whether any testing, especially with respect to Ms. Brown, was a result of attorney work product.
Maybe they should have produced it, right? That's why you do things, or maybe you should have produced it and said, look, Judge, you know what? We done testing and we think potentially it might be work product or something like that, but it should have been produced, should have been identified. I should not find about testing in any case while a witness is on the stand.
Your Honor, given the $38 million sanction that resulted in this case, again, we respectfully submit that an evidentiary should have occurred. And
well, let the Supreme Court tell me that, because I don't know what else I need to know. Let them tell me what I needed to know, because I know there was testing done. I don't think I had to perform a hallmark type analysis regarding the admissibility or whether or not the qualifications requirement were met, whether the assistance requirement was met. I don't have to do any of that. We know there was testing and it was never produced. And so what are we going to do? Produce testing on the 7th week of trial, 6th week of trial, whatever the time period might be. And then I'm going to bring the jury in. Okay, let's have an hour. No, we'll have a day hearing and we're going to have an evidentiary hearing, right? That's what you're saying I should do. And in a 6-week trial where we had probably 10 to 12 weeks of pretrial motion practice, right? Then I'm going to let the jury sit and we're going to have an evidentiary hearing. And at the end of the day, I'm going to find out they did testing and they didn't produce it, right? Whether the testing was admissible or not, whether the tester met the qualifications requirement under hallmark, I don't think any of that mattered, right? I really don't. And then what do we do too? Then I look at it, okay, from the plaintiff's perspective, do they get a chance to call their witness back and rely upon the testing, right? I look at it this way. If there's testing done and it wasn't produced, and there's actual testimony during trial that testing was performed, and then we have admissions by counsel that there was testing done, and he says, you know what, I believe Mr. Parker is making an assumption as to whether or not she would be able to talk about the testing she has done, because I haven't provided that. I can't do that, but her testing has stopped there. That's a problem. I don't mind saying it.
Your Honor, arguments of counsel are neither facts nor evidence.
We got facts, right? Witness testified that there was testing, and counsel actually went beyond Mr. Savaggio's testimony. He admitted, he said, okay, real simple. Laura Brown has done testing, right? And I don't think counsel would lie about that, right? That's admissions by counsel. Yes, there was testing done. And I don't mind saying it, counsel, that I respect. It's appeared in front of me 100 times plus. He's being honest and candid. He could have said, oh, no, Judge, there was no testing. Right? No, he told the truth.
Your Honor, we're not disputing about whether there was testing by Mrs. Brown. Again, our argument is that this court, the details mattered in this, and they mattered for the record. They mattered to this court's analysis, and that an evidentiary hearing should have been held. Respectfully
disagree. And what would the evidentiary hearing disclose? That's what I want to know. What would it disclose? What exactly did I need to know at the evidentiary? Because I don't need to, I'm not performing a hallmark analysis, right?
Your Honor, I would probably, when the testing was done.
How we know, done. Because did Mr. Rasmussen just say that?
He did, Your Honor. He said in March.
March, yeah.
How the testing.
He said in March, and the trial started September.
Your Honor.
I'm sorry, counsel.
Wait. What you're telling me to do is I have to have an evidentiary hearing along with a hallmark type hearing to make a determination as to whether this testing would be admissible or not before I issue sanctions. But the testing wasn't ever produced.
Your Honor, given the nature of these sanctions, yes. And
I don't think the Nevada Supreme Court was going to require me to hold a hallmark hearing before issuing sanctions in this case to determine whether or not the testing protocol and procedures in place had merit or lacked merit.
in Your Honor, it's an evidentiary hearing again pursuant to the Hanna. And
I can't wait to hear from you, Mr. Polsenberg.
I can't wait either.
and with that, I will submit our arguments. We request that the court grant our motion for a new trial. The sanctions that resulted, to which Hanna is jointly and severally liable, were unprecedented and disproportionate to the alleged conduct. Thank you, Your Honor.
Thank you, sir.
Judge, I'll be brief.
Mr. Polsenberg, what do you got to tell me, sir?
I think Milwaukee has to join in Hanna's motion and arguments, and I think the evidentiary hearing we're talking about here is different from Hallmark. I think it's counsel keeps mentioning Hanna. Hanna came after Nevada Power, and there the Supreme Court said there had to be an evidentiary issue to decide intent and prejudice, two of the key Johnny Ribeiro factors. So if you're going to whether it was admissible, that would be one of the things, of course, Your Honor, would have to decide to see if there was prejudice.
But why would I have to make a determination as to admissibility or perform some sort of hallmark analysis? Because at the end of the day, the testing was done, and that's a fact, right?
Well, and the cooling tower being destroyed was a fact in Nevada Power.
Yeah, but
we all knew that.
Yeah, but here it's a fact that there was testing done, and it was never disclosed.
And you have to look at the intent in that, and you have to look at what the prejudice is. I think admissibility might be a factor in prejudice, but it is not what the scope of the evidentiary hearing would be about.
What would the evidentiary hearing be about, Mr. Postman?
It would be about intent. Did these people intentionally conceal or destroy evidence, and prejudice?
Well, when you say intentionally, what conclusion can I come to when there's an ongoing obligation when you perform testing with an expert, and testing has been performed to identify that and produce it?
The fact that there was a violation doesn't make it an intentional violation. Now, I know Teddy's going to at some point out that I'm an appellate lawyer and I don't know what I'm talking about. And
no,
yes,
Mr. Postman, I like listening to you. Go ahead.
And I love watching you pull the wings off my flies, Your Honor. So, but the issue, I don't think the issue was fully resolved. You looked at it as a violation. I understand that reflex, but you have to look at the severity of the sanction. You have to consider those factors, and all 7 of the Johnny Ribeiro factors, but especially intent and prejudice. And that was what Nevada Power was about. Okay. In Nevada Power, there was no showing that the destruction of the cooling tower actually prejudiced the plaintiffs in that case.
Here's my next question. What type of evidence can I look at as a trial judge when it comes to making those types of determinations? Can I make the decision based upon direct evidence, circumstantial evidence? The scenario where here we have a witness testify on the stand in open court that there was testing done that was never produced. And then I have discussions by defense counsel, who I really respect and like, and he's a fine lawyer. I just want to make sure the record's clear. When he admits, okay, real simple, Laura Brown has done testing. That doesn't mean I was going to put her on the stand to do that. I believe Mr. Parker's making an assumption as to whether or not she would be able to talk about her testing she's done because I haven't provided that. I can't do that. But her test, I guess it goes on further. But
see, what you would do in an evidentiary hearing on sanctions goes far beyond what a jury would be able to hear. Right. So you could look at all sorts of circumstances in that, not just look at the testimony from the stand in front of the jury.
What are those circumstances?
What are they in this case? I don't know.
Okay. That's what I know. That's my point. I mean, I understand everyone saying, look, judge, you got to have an evidentiary hearing. Sometimes yes, sometimes no. And here's my point. There's no factual dispute about testing, right?
Right.
There's not. That's
That
like,
was in Bahena. There were no disputed facts in Bahena.
right.
And counsel said, well, here's what happened. And the Supreme Court said, you don't need an evidentiary hearing there because all the facts have been represented.
Okay.
Exactly.
I understand that.
Thank you, Your Honor.
Thank you, Mr. Ford.
Your Honor, can I address what Mr. Polsenberg said?
Yes, you can.
All right. Unless someone else wanted to go ahead of me, I don't want to step on anyone's toes. All right. Hearing none. Mr. Polsenberg, I think, has refined the issue. He recognizes that in Bahena, no evidentiary hearing was needed and there was no case terminating sanctions imposed. There were no case or terminating sanctions.
No. You'll get a chance to
No,
remember.
but I never said that.
Okay.
I think the sanctions here were sufficient that you have a higher standard of review that applies. All I said about Bahena was there were no questions of fact in Bahena.
And Mr. Polsenberg will get up again, I'm sure. But Your Honor, the point is in Bahena, case terminating sanctions were not provided ultimately, and an evidentiary hearing was not required. And that's a true statement. What we also know is, because Mr. Polsenberg and I was a part of this case as well, the Clark County School District case. In that case, there was an evidentiary hearing because case terminating sanctions were being sought. Unfortunately, Judge Levitt, in her implementation of the sanctions in the Supreme Court's opinion, went beyond, and that case was reversed. But the point was, and I think it's the same, be it Bahena or, it was a long time ago when Nevada Power case was out, but certainly Mr. Polsenberg was involved and Rex Jemison was involved. And I think Judge Gonzalez, former Judge Gonzalez, was involved in that case, and with the tower being torn down. And I agree with Mr. Polsenberg how that case was ultimately decided. I think Judge White was involved in that case. No, was Judge White?
It was Judge White.
Yeah, that's what I thought. And so, long time ago, Your Honor. But the point being, you go to the Young-Ribeiro factors when you are making the determination on case terminating sanctions. And so when Mr. Polsenberg brings up the Young-Ribeiro factors, or when Hanna's counsel attempts to bring in the Young-Ribeiro factors, those are the factors to be considered when you're imposing, that have to be satisfied and considered when you're imposing case terminating sanctions. Let's not get away from what the court did. The court did not impose case terminating sanctions. And no matter how Hanna's counsel would like to call the heart of the case or describe it as such, as being what the court has affected, that's not what the Supreme Court has decided. If it's case terminating sanctions, your answer is struck as a defendant, and you can't argue any of the plaintiff's claims. The plaintiff, simply based upon the Richardson, the Clark County School District case, still has to prove its case in chief, which I think Mr. Polsenberg recalls specifically, and I saw him shaking his head affirmatively. But but Your Honor, we did that. And what I would also say, which no one can deny, Hanna and Milwaukee had the benefit of cross-examining every witness that we had prior to this sanction being imposed. They had the benefit of that going through our entire case in chief. And it wasn't until their case in chief that we figured out or found out that testing had been done through Carl Salvaggio's testimony on behalf of Hanna. And I take some exception to Hanna's counsel talking about how these sanctions and how big of a case this was and why Hanna should not have been sanctioned in the way it was. But I want the court to consider the converse of this. We had a person who died as a result of the conduct of Real Water and Hanna and Milwaukee. We had several other plaintiffs, including a child who went through being life transported by plane from Las Vegas to Salt Lake City to the Primary Children's Hospital with fear of having to go through a liver transplant within months of being born. This was a horrible set of circumstances, and the misconduct by Hanna deserved, in my opinion, greater sanctions, but the court, again, was tempered. The court was judicious in its application of the rules and did not impose case terminating sanctions. So if the Supreme Court ever looks over this court's shoulder, it should be able to say, looking at Young Ribeiro, it did not have the obligation to consider all of the factors under Young Ribeiro because it did not impose case terminating sanctions. And looking at the Bahena case, even if it was Milwaukee who originally brought the request for an evidentiary hearing, again, the court did not impose case terminating sanctions, so an evidentiary hearing was not required. And then finally, Your Honor, you have given Hanna's counsel and Mr. Polsenberg, Milwaukee's appellate counsel, an opportunity to tell you what this evidentiary hearing what fruit it would have borne. It would have borne for them. And I will tell you, Your Honor, at least, Mr. Polsenberg said he doesn't know what would have been the results of the evidentiary hearing. Hanna's counsel has not given us anything except questions that potentially could have been asked. But, Your Honor, having heard that testimony, and I had Mr. Salvaggio on the stand for quite a long time, and I appreciate what Mr. Odou said, that Mr. Salvaggio perjured himself at least 7 times, I think is what Mr. Odou said. But one thing he did say is there were testing done. And one thing that Mr. Rasmussen said, which is consistent with what Mr. Salvaggio said, is there was testing done. There had to be a sanction imposed based upon their failure to comply with 16.1, their failure to comply with Rule 33 and 34, and their failure, in addition, under 16.1, to provide as a part of their expert's job file information on testing and the testing protocol that Hanna was aware of. And none of that was done. And so, Your Honor, there is no excuse for their misconduct, and an evidentiary hearing would not have given you any more information than you needed to make the less than terminating sanctions imposed, Your Honor. That's all I have.
All right, you get a chance to both Mr. Reynolds and Mr. Polsenberg get the last word.
Just briefly. Council brings up the Clark County School District versus Richardson construction case from 2007. I'm pretty sure every case Teddy had in 2007 was called Clark County School District versus Richardson. But in that case, there was nowhere near the sanctions. There, Judge Michelle Levitt struck the affirmative defenses. Plaintiffs were still allowed to attack the plaintiff's prima facie case. We're allowed to defend the case. That's not what happened here. And Judge, I will say that I think when you impose liability as a sanction, that in those circumstances, that is so egregious that you have to follow Nevada power, not just have an evidentiary hearing to find out the answers to the questions you're asking
But
now.
What I want to know is what would the evidentiary hearing establish? Because here's my point, and I think it's valid. You say, Judge, you have to have an evidentiary hearing for what? To determine the admissibility of the potential.
No, Judge, I keep saying that's not the evidentiary hearing. This isn't Hallmark. This is Nevada
Okay,
power.
what would I have to find out that I needed to know that I didn't?
You'd have to determine that there was intent, and you'd have to determine the degree of prejudice.
Well, I thought the prejudice was fairly significant. That's why I granted yeah, I mean, I don't know what here's my point. You say, well, Judge, you have to know the degree of the prejudice. Well, I'd listened to 10 weeks of law in motion, and this is probably week 4 of the trial. So I understood this is significant prejudice by withholding testing information.
And Judge, tell me what the prejudice was.
Testing was performed. It was never disclosed.
But
We
that's
don't know
not
what it
prejudice,
is.
Judge. That's just the violation. in Nevada Power, the Supreme Court reversed Judge White, sent it back down for an evidentiary hearing. How exactly were the defendants harmed in that case? Because the plaintiffs had allegedly destroyed evidence.
But they did, didn't they?
Yes, they totally did.
Yeah, they did.
They totally did. So was there prejudice? Don't know. Nobody bothered to look. The prejudice was assumed. And here you did the same thing. Thank you, Your Honor.
All right. Anything else, Mr. Reynolds?
Your Honor, agree and concur with Mr. Polsenberg's arguments. And again, want to hit home, the record is void of evidence of prejudice in intent. And again, to echo, that's why an evidentiary hearing was necessary in this case. Thank you.
Couple of things, and I think this is often overlooked. As far as intent's concerned, you can look at that in two ways. Number one, direct evidence. Number two, circumstantial. Clearly, and the law mandates that can give equal weight to both, right? We have jury instructions on it. And I look at it from this perspective. If lawyers are doing something and they don't disclose it, that's a problem, right? It just is. And secondly, and looking at Mr. Rasmussen, and I respect him for this, but he said they did testing, and he says, quote, that doesn't mean I was going to put her on the stand to do that. I believe Mr. Parker is making an assumption as to whether or not she would be able to talk about the testing she's done because I haven't provided that. What can I infer circumstantially from that? It didn't help their case. Right? It did not help their case circumstantially, because if it did, they would have produced it. That's how I see it. And so we can talk about potential prejudice. It wasn't produced. And so anyway, as far as the motion is concerned, I'm going to deny. We'll move on to the next one.
Thank you, Your Honor.